Hello everyone, my name is Yan Mengyuan. I come from Coventry University and my major is global journalism. Today I want to talk about the defamation legislation in England and Wales. Before I start my presentation, let's take a brief look at the outline. I've divided my talk into 7 parts. First, I will illustrate what is defamation. Second, to describe how and why defamation legislation has evolved. Then, I want to briefly show how defamation relates to ethics. Next, analyze the performance of the legislation with the work of journalists. In the fifth part, there is a case application to support my topic. In the end, there is a conclusion of my presentation. The last part is the reference list. What is defamation? Defamatory statements are those published or spoken which affect the reputation of a person, company, or organization. Defamation includes 2 types: written statements called libel and spoken statements called slander. Then I have a question, which is how and why defamation legislation has evolved. The British defamation legislation can be traced back to 11th century to protect the important people of the kingdom from the intrusion of the story they disliked, and mainly through the harsh punishment to achieve. The promulgation of the draft defamation bill in 2011 reflects the public's demands for freedom of expression. In some important respects, government struck a fair balance between the protection of reputation and the freedom of speech. Justice Minister Clarewood said, "Sedition and seditious and defaming libel are arcane offenses from a bygone era when freedom of expression wasn't seen as the right it is today. The outdated offenses of criminal libel and sedition have been abolished after the introduction of new laws." Defamation Act 2013 aimed to give better protection to people expressing their views in England and Wales. The government said that the law would overturn the chilling effect of the current defamation laws on freedom of speech. In the case study section, I will make a further explanation about this question through a famous case. How defamation relates to ethics. The law is based on pragmatism and it maintains conservatism, and it is required to perform the function of social requirements. Early law faced an ethical problem in dealing with defamation, but the solution cannot be compared with the individual moral standards. Fundamentally, the rights and obligations that the law provides to protect the interests of personal reputation are theoretically consistent with morality. Next, I want to briefly analyze the performance of legislation with the work of journalists. All journalists need to understand the law and how it affects their work. Most journalists believe that defamation laws are trying to achieve balance between protecting the reputation and the freedom of speech. And journalists need to know how defamation defenses work, because they often consider avoiding defamation when researching and writing stories. Now let's move on to case study section. In this section, I'm going to describe a very famous case from England. Dr. Simonson, a physicist, and also he is a popular British science writer. If you read The Big Bang, then you must know him. In 2008, Guardian published Simon's feature, "Beware the Spinal Trap." Then the British Chiropractic Association sued Simon for defamation. Simon in his article sued the phrase happily promotes bogus treatments. At that time, the BCA was promoting chiropractic for treating the children's ailments. Simon thought, lack of evidence to prove this replacement therapy is effective to human body. A judge said his article in effect accused the BCA of deliberate dishonesty in promoting the treatments, which Simon has maintained was not his intention and would be hard to defend. Simon decided to sue against the ruling, which raised substantially the potential financial liability that he would face if he lost the case. Leave to appeal was granted in October 2009. In April 2010, they allowed Simon's appeal, ruling that the High Court judge had erred in his approach. The Court of Appeal overturned the previous ruling that Simon's comments were an assertion of fact and instead ruled that Simon was qualified to defend his comments as legally permissible fair comment. This case has made a stir in scientific community and contributed to the reform of defamation laws. On 25th of April 2013, the Defamation Act 2013 received the Queen's royal assent and became law. The purpose of the reformation of defamation legislation is to ensure that a fair balance is struck between the freedom of expression and the protection of reputation. Under the new law, new defenses of truth and honest opinion are also part of the key areas of the new law. To sum up, the defamation law is intended to protect those whose reputation is violated. The defamation in England and Wales has a long history and has had a significant impact on countries around the world. In order to balance the right of reputation and freedom of expression, England and Wales through the theory and practice to reform defamation legislation gradually. Okay, this is my reference. I used the Harvard style to list. Thank you very much. If you have some questions, please ask me. I will do my best to answer them. Thank you.